Hello, my name is Zev Brooks. I'm an attorney. I practice law in California. I've been practicing in the areas of estate planning and probate for nearly 2 decades, and I'd like to bring you a basic overview of the California probate process. So to begin, let's discuss who are the players in the California probate process. There are 3. The first is the person who died. That person's called the decedent. Then there are the people who are inheriting property from the decedent. They're the beneficiaries. And the third is the personal representative. This is the person administering the estate on behalf of the decedent for the beneficiaries. Now, the first thing we have to ask ourselves is a probate actually necessary? You see, in California, not everything the decedent owns at death needs to go through the probate process to be transferred to beneficiaries. In fact, there are major categories of assets that can avoid probate entirely and still be distributed to the beneficiaries. One of these is jointly held property. For instance, if you hold a joint bank account, the decedent has a joint piece of property. Upon death, the surviving joint tenant inherits that asset without any probate. Another category of these assets is pay-on-death property. For instance, life insurance. A beneficiary of a life insurance policy will get those funds, no probate's necessary. Maybe you have a stock account and the decedent named a beneficiary, no probate is necessary. Another category are assets in a living trust. That is a trust the decedent put together while he or she was alive and put property into the trust. Assets in a living trust, they avoid probate as well. Assets passing to a surviving spouse avoid the full-blown probate procedure. It might be necessary to do a summary procedure in the California courts, but a full probate isn't necessary. If the decedent had an estate worth less than $150,000, no probate is typically necessary. Or the decedent owned real property, $50,000 or less, no probate is necessary. So when is a probate actually necessary? Well, it's typically in cases where a decedent is a single person, either divorced, widowed, widower, never married, owns real estate in his or her name alone or assets in his or her name alone that are worth over $150,000. So once you determine a probate is necessary, that brings us to the first step of the process, which is filing a petition. The first step in the probate process is filing a petition to have somebody appointed a personal representative. You file the petition and a hearing will be set in court anywhere from 6 to 8 weeks out, really depending on the county where you file the petition. Now, after you file the petition, there are some procedural steps you need to take. Notice and publication. Notice is just informing the people that are mentioned in the will or the decedent's intestate heirs, or typically both, that you filed a petition and you want to be appointed the personal representative. You also need to do something called publication. Publication is like those legal notices you see in the back of a newspaper. So in the city in which the decedent died, in a paper of general circulation, they'll publish a notice that this hearing will be set and what date it's set and so on. This way, anyone who has an interest in the estate can show up on the date of the hearing and object. Now, hopefully they don't object, and after you filed your petition, everything's in order, you gave your notice, you gave your publication, then on the hearing date, you will be issued something called letters. Letters is the document the personal representative can use to show that he or she has authority over the estate. With letters in hand, the personal representative can deal with third parties, sell real estate, open and close bank accounts. The personal representative stands in the shoes of the decedent. One thing to note, sometimes the court might require a bond. A bond is like an insurance policy. What happens is, if the personal representative mismanages the estate or runs away to Tahiti with the money, an insurance company will pay the beneficiaries their rightful inheritance and then go after the personal representative for reimbursement. This is a bond. A lot of times a will waive a bond, and sometimes beneficiaries don't want a bond and they can waive a bond as well. The reason being, a bond can be expensive and it takes money out of the estate that otherwise would go to the beneficiaries. In any event, once you have your letters, you're done with the first step of probate and we're on to the next step, which is dealing with an inventory and appraisal. When letters are issued, the court will assign someone called a probate referee. Sometimes the personal representative has to ask the court to assign a probate referee. But this probate referee is the official appraiser of the estate, and it's the probate referee's job to give the estate a date of death value. Now, all cash in the estate, that is money in bank accounts and cash, the personal representative can assign a date of death value because it's easy to look it up. Just refer to a bank account statement. You know how much money the decedent had when he or she died. But every other type of asset, real estate, stocks and bonds, patents, trademarks, royalties, a car, any asset that's not cash is given a date of death value by the probate referee, and this document, an inventory and appraisal, is filed with the court. Now, a date of death value is important because it establishes a starting point for when later in the probate process you're going to tell the beneficiaries what they're going to get. We need to know how you got from the date of death value to the assets on hand to distribute. And that's where the date of death value comes into play. Also, attorney's fees and personal representative fees are based in large part on this inventory and appraisal. The next step of the probate process is the actual administration. After letters are issued, the personal representative now stands in the shoes of the decedent. So the personal representative now has legal authority to sell real estate, dispose of a vehicle, talk to the banks and other institutions holding the decedent's money, open up an estate account, deal with the IRS. The personal representative during administration also has to give certain notices. For instance, if the decedent received Medi-Cal benefits or the deceased spouse received Medi-Cal benefits, then you need to inform the California Department of Health. If there's a beneficiary in prisons, notice needs to be given. If there is, you need to give notice to the Franchise Tax Board to see if the decedent owes any taxes to the California state. So during the administration process, notices are given, and the personal representative with letters in hand starts administering the estate. The fourth step in the probate process is dealing with creditors. You see, the court is interested in making sure not only that the beneficiaries get what they're entitled to, but that the decedent's creditors get paid as well. Now, creditors are defined as debts the decedent had prior to death, like credit card debts. It could be hospital or medical bills, utility bills prior to death, anything the decedent owed prior to death. You see, the personal representative needs to give notice of the administration to the creditors. The creditors then have to file a creditor's claim. They have to file this claim within 120 days after letters were issued or within 60 days after they received notice from the personal representative, whichever is later. Now, if the creditors don't file a timely claim, they waive their rights to get paid, which is a good thing for the beneficiaries because that means there'll be more money in the estate. If a creditor does file a timely claim, the personal representative either pays the claim or can reject the claim. If the claim is rejected, then the creditor has to bring a lawsuit against the estate within 90 days. If the creditor doesn't do that, the creditor waives its rights as well. Also, there's a hard and fast 1-year statute of limitations for debts of the decedent. So if the decedent has credit card debt, a year goes by and then you open up a probate process, well, that credit card company is out of luck because a year has passed and the statute of limitations has not been met. Dealing with creditors is complicated. It's a complicated part of the probate procedure, but it's a very important part of the probate administration because, again, the court is going to make sure that creditors were properly dealt with. Another thing you should understand is that when you're administering an estate, there's a minimum administration period of 4 months. That means that once you get letters, you can't ask the court to distribute to the beneficiaries until at least 4 months have gone by. Even if the estate is a simple estate, one beneficiary consisting of $180,000 cash in one account, and there are no creditors, you still need to wait that minimum 4-month period before you can ask the court to distribute the estate. Which brings us to the next step, closing out the probate. As long as 4 months have elapsed after letters have been issued, the personal representative can bring to the court a final accounting, a request for distribution, and a request for fees. Now, this accounting is for the benefit of the beneficiaries and those interested in the estate. You file the accounting, and a hearing date will be set. Sometimes it could be 3 months from the time you file the accounting, but then again, that depends on the county. The purpose of the accounting is to explain to the court and to the beneficiaries how you went from the date of death value of the estate, that established by the probate referee, to the cash and assets you have on hand that you're ready to be distributed. The accounting also deals with the payment of attorney's fees and the fees for the personal representative. These fees aren't paid until the beneficiaries receive their money, and the court has to approve those fees. Now, an accounting can be waived. If you have a simple estate and the beneficiaries, for some reason, aren't really necessarily interested in how you got from point A to point B, then you file a waiver of an accounting. You still ask the court to authorize a distribution, and you still discuss attorney's fees and personal representative fees. Now, you don't need to do any kind of publication when you file an accounting. Just give notice to those who are the beneficiaries and who are interested in the estate. The last part of the probate process, and probably the most fun, is distribution. Once the court approves your accounting and gives you authority to distribute the estate, now the personal representative literally does just that. Distributes money to the beneficiaries or retitles property in kind if a beneficiary is getting, let's say, real estate. Distributions are made, and the personal representative obtains receipts from all the beneficiaries. Those receipts are then filed with the court with a simple petition called an ex parte petition for discharge. Once that's filed, the case is over and the personal representative is discharged. So just like the case began with filing a petition to get the personal representative appointed, the case ends when the personal representative demonstrates that he or she did his or her job by filing the receipts, and that ends the case. Also at this time, if there was a bond, the bond company will exonerate the bond, so there's no more liability there. So this is the basic overview of the California probate process. In the real world, there's a lot more detail, and there are issues I didn't discuss that might arise in any particular case. And typically, if the probate process goes smoothly, it'll last 9 to 12 months because of the 120-day administration period and the time it takes while you're waiting for your court hearings after you file your petition or after you file your accounting. Thank you for watching. I hope you found this presentation informative. I'm happy to discuss your case with you. At that time, we can discuss probate fees, attorney's fees, probate costs. So please email me or give me a call, and I look forward to hearing from you.